This tutorial is produced by the Mecklenburg County Clerk of Superior Court, Estates Division. While our office cannot provide legal advice, we are happy to help you navigate the estates administration process. This video will provide a step-by-step guide to completing the affidavit for collection of personal property. First, let's define some of the terms used in this tutorial with which you may not be familiar. Decedent, a person who has died. Affidavit, a sworn or affirmed statement that has been made under oath. Affiant, the person who is making a sworn or affirmed statement under oath. For this form, the affiant is also the person making the request to collect the decedent's personal property. Executor, a person the decedent named in a will to be in charge of the administration of the estate. Administrator, a person in charge of the administration of an estate when the decedent did not leave a will or when the decedent's will cannot be probated. Public administrator, a county official placed in charge of the administration of the estate. Codicil, a document executed as an addition or supplement to a will which adds to, takes from, or alters the provision of the will. Heir, a person who is able to inherit from a decedent who did not leave a will. Devotee, a person who can inherit from the decedent's estate because the decedent named the person as a beneficiary in a will. Probate, the legal process in which the decedent's estate is administered. What is the purpose of this process? This process allows the applicant to collect personal property that was owed to the decedent. If a person is indebted to the decedent or has personal property belonging to the decedent, he or she must make payments or deliver the decedent's personal property to the collector. Only the decedent's personal property may be collected using this affidavit. The affidavit for collection cannot be used to collect real estate. When is an estate considered a small estate? The answer to this question depends on when the decedent died. If the decedent died on or before September 30th, 2009, it is a small estate when the value of the personal property owned by the decedent after liens and encumbrances is not greater than $10,000. When the affiant is both the decedent's surviving spouse and sole heir or devotee, the amount increases to $20,000 while still taking into account liens and encumbrances. If the decedent died on or after October 1st, 2009, it is a small estate when the net value after liens, encumbrances, and the spousal allowance is not greater than $20,000 and a personal representative has not been appointed. When the affiant is both the decedent's surviving spouse and sole heir or devotee, the amount increases to $30,000 while still taking into account liens, encumbrances, and the spousal allowance. When may the process for a small estate begin? The affiant may submit the affidavit when 30 days have passed since the decedent's death. Who qualifies to collect the decedent's personal property? Persons who qualify include a person named as executor in the decedent's will, an heir or devotee, a creditor, the public administrator. Persons who cannot collect the decedent's personal property include, but are not limited to, persons under 18 years of age, persons who a court has deemed incompetent and who remain with the disability, persons convicted of a felony who have not had their citizenship restored, persons who have committed acts which, under the law, bar a person from inheriting from the decedent, persons who cannot read or write, A person who the clerk of court finds to be otherwise unsuitable to administer the decedent's estate. What documents must an affiant provide to the clerk's office when filing to administer a small estate? The affidavit for collection of personal property must be completed and submitted to the clerk's office. There are two versions of this form. The form that an applicant will use depends on the decedent's date of death. Form AOC-E-203A must be completed if the decedent died on or before December 31st, 2011. Form AOC-E-203B must be completed if the decedent died on or after January 1st, 2012. Along with the affidavit for collection of personal property, the affiant must provide the decedent's death certificate. If the decedent had a will, the affiant must also file the original will. If there are codicils to the will, these original documents must also be provided. The affiant must supply any available supporting documentation regarding the assets left in the decedent's name. This may include information regarding bank accounts, insurance, retirement funds, stocks and bonds, and vehicle registration. If this information is unavailable to the affiant at the time of filing, it may be provided at a later time. The clerk's office also requires a family history affidavit to verify the identity of the decedent's heirs. There is a separate tutorial to help you complete this form. If the affiant is not a North Carolina resident, he or she must also complete the Appointment of Resident Process Agent form. This form names a North Carolina resident who will be the court's point of contact if the affiant cannot be reached directly. This assigned person may then receive on the affiant's behalf any documents the court may issue concerning the estate. The assigned person must sign the appointment form in the presence of a notary in acknowledgement of his or her willingness to serve as the resident process agent. The General Court of Justice and facilities fees for this filing total $120. Acceptable forms of payment include certified check or money order. Cash, credit, or debit card may be used if the payment is made at the courthouse. How to complete the affidavit for collection of personal property. Enter the county where this form will be filed. Enter the decedent's name, street address, city, state, and zip code. Enter the last 4 digits of the decedent's social security number and the decedent's county of residence at the time of death. If the decedent did not leave a will, check the first box labeled intestate. If the decedent did leave a will, check the second box labeled testate. Include the decedent's date of death and the date the decedent signed his or her will, if the decedent left a will. Enter the place of death here only if it is different from the county where the decedent lived at the time of death. Enter the name, street address, P.O. Box, city, state, and zip code of the affiant. If there is a second affiant, enter this same information for the second affiant in the section to the right. Include the telephone number for each affiant listed, as well as the county and state where the affiant lives. Enter the name, street address, P.O. Box, city, state, and zip code of the attorney who is helping the affiant with this process. If there is no attorney, leave this section blank. If an attorney was listed, enter the attorney's telephone number and, if known, the attorney's state-issued bar number. Check the box that correctly identifies the affiant and confirm that the affiant is not disqualified from the role. Check the first box if the affiant is an heir. Check the second box if the affiant is an executor named in the will. Check the third box if the affiant is a devotee named in the will. The fourth box, public administrator, would be used only by the county official appointed to that role by the Clerk of Superior Court. Check the fifth box if the affiant is one of the decedent's creditors. Confirm that at least 30 days have passed since the decedent's date of death. Check the first box if the decedent did not leave a will. Check the second box if the decedent left a will. If you are completing AOC-E-203A for a decedent whose date of death is on or before December 30th, 2011, check the first box if the decedent died on or before September 30th, 2009, and if the net value of the decedent's personal property is not greater than $10,000 after all liens and encumbrances have been deducted. Check the second box if the decedent died on or before September 30th, 2009, if the affiant is both the decedent's surviving spouse as well as the sole heir or devotee, and if the net value of the decedent's personal property is not greater than $20,000 after all liens and encumbrances have been deducted. Check the third box if the decedent died between October 1st, 2009 and December 31st, 2011, and if the net value of the decedent's personal property is not greater than $20,000 after all liens and encumbrances have been deducted. Check the fourth box if the decedent died between October 1st, 2009 and December 31st, 2011, if the affiant is both the decedent's surviving spouse as well as the sole heir or devotee, and if the net value of the decedent's personal property is not greater than $30,000 after all liens and encumbrances have been deducted. If you are completing AOC-E-203B for a decedent whose date of death is on or after January 1st, 2012, check the first box if the net value of the decedent's personal property is not greater than $20,000 after all liens, encumbrances, and the spousal allowance have been deducted. Check the second box if the affiant is both the decedent's surviving spouse as well as the sole heir or devotee, and the net value of decedent's personal property is not greater than $30,000 after all liens, encumbrances, and the spousal allowance have been deducted. Check the box if the decedent died leaving a will that has been probated. Confirm that no application or petition for a personal representative has been granted, and that there is none pending in this or any other jurisdiction. Identify any persons who are allowed to take a share of the decedent's estate. List their names, ages, relationship to the decedent, and mailing addresses. If exact ages are not known, print an A for adult or an M for minor in the age column. Once the first page of the form is completed, turn to the back page to complete the preliminary inventory of the decedent's estate. The first portion of the form includes property of the estate. The estimated market value of the decedent's property at the time of the decedent's death is required for each field. If more space is needed, the information can be included on a separate sheet and attached to this form. List any accounts that are in the decedent's name only. Be sure to include the bank's name, each account number, and the amount remaining in the account. List any accounts that the decedent shared with another person, but that did not automatically transfer to the survivor upon the decedent's death. Be sure to include the bank's name, each account number, the amount remaining in the account, and the names of the other account owners. Also include the percentage of the account that the decedent owned. Include the percentage of any stocks, bonds, or securities owned solely in the decedent's name, or those that the decedent shared with another person, if the person did not get full ownership upon decedent's death. Provide the estimated market value for any of the following assets that are part of the decedent's estate: cash and deposited checks on hand, household furnishings, farm products, livestock, equipment, and tools, vehicles. Remember to print on the form the complete description of the vehicle, including the vehicle identification number, year, make, and value. If there is not enough room in the space provided, the description can be attached to the form. Interest in partnership or sole proprietor businesses. Insurance, retirement plan, IRA, etc., that are payable to the estate instead of directly to a beneficiary. Notes, judgments, and other debts owed to the decedent. Miscellaneous personal property. Estimated annual income that the estate will continue to earn after the decedent's death. If there is real property that the decedent has willed to his or her estate, or to the executor of the estate in that person's role as executor, instead of to them as an individual, then the affidavit for collection is not the appropriate form to file to open the estate. Once all the amounts are listed, add the values in the far right-hand column together and enter the total amount for Part 1. The second portion of the form requires a listing of property which can be added to the estate if needed to pay claims. An estimated market value is required for each item of property listed. List any accounts that the decedent shared with another person if the survivor received full ownership of the account after the decedent's death. Be sure to include the bank's name, each account number, the amount remaining in the account, and the names of the account owners. Include the estimated market value for any stocks, bonds, or securities that were either transferable or payable directly to a beneficiary upon the decedent's death, or shared with another person who received full ownership after the decedent's death. Include the estimated market value for other personal property that is recoverable by law. This category includes the following types of personal property: accounts which are called trustee accounts in the signature card or deposit agreement, or in which the decedent otherwise established a tentative or taught-in trust. Securities registered in beneficiary form and automatically transferred on death. Property which the decedent gave to someone in contemplation of his or her own death. And property transferred by the decedent without receiving adequate consideration, with the intent to hinder, delay, or defraud his or her creditors. If you believe there may be any property which falls into this category, you may wish to consult an attorney. Here, list real estate owned by the decedent that is not identified in any other section of the form. List the value and attach a description of the real estate that includes either a full address or the parcel ID number. Once all the amounts are listed, add the values from this section together and enter the total amount for Part 2. Part 3 of the preliminary inventory includes other types of property that the decedent may have owned at the time of his or her death. Check the first box if the decedent was married and owned real estate jointly with a spouse. Check the second box if the decedent did not own real property with a spouse. Check the first box if there are any insurance, retirement plans, IRA accounts, etc., that the decedent made payable to a named beneficiary upon his or her death. Check the second box if the decedent did not leave insurance, retirement plans, IRA accounts, etc., that were payable to a named beneficiary. When the form is completed, each affiant must sign the form as the collector by affidavit. Do not sign until your signature can be witnessed by a person authorized to administer oaths. This is typically a notary public. Neither the affiant nor the notary should write anything below the certification line. When the affidavit for collection has been completed, signed, and notarized, submit the form for filing along with these other previously mentioned items. Death certificate. If the decedent had a last will, the original, and, if applicable, any original codicils to the will. All available supporting documents for the decedent's assets. Family history affidavit. If the affiant is not a North Carolina resident, the appointment of resident process agent form. A cashier's check or money order for $120 payable to Clerk of Superior Court. If the affidavit for collection is accepted, the clerk's office will issue to the affiant documents which will authorize the affiant to collect the decedent's personal property, use the value of the property to pay the decedent's debts or expenses, and divide any remaining funds after these payments are made among the decedent's heirs or devisees. When the affiant has completed this process, and within 90 days, the next step is to complete the affidavit of collection, disbursement, and distribution. After preparing your paperwork in accordance with this tutorial, you may bring your documents and the filing fee to the Mecklenburg County Courthouse and leave them with the Estates Department. Or you may mail these items to the following address: Clerk of Superior Court, Estates Division, P.O. Box 37971, Charlotte, North Carolina 28237. I hope this information has been helpful. We look forward to assisting you.